Welcome to the lecture on informal fact gathering and investigation. In this lecture, we're going to be looking at what paralegals commonly do before a lawsuit is filed and sometimes immediately after. But there are some big benefits to a pre-suit investigation on the part of the paralegal before either the attorney decides to take the case, and if the attorney does take the case, before the suit is actually filed. First of all, investigating the facts to the extent possible before suit will enable the paralegal and attorney to ascertain any causes of action the client may have, or if the client happens to be a defendant, what defenses the client may have. In addition, in this investigation helps identify potentially relevant witnesses and other evidence involved in the case. It will also help the paralegal or attorney ascertain those facts and legal theories that they will want to plead in the complaint or answer that will ultimately be filed with the court. Now, of course, doing a reasonable pre-suit investigation will help avoid filing a frivolous pleading in violation of Federal Rule of Civil Procedure 11. That rule provides that if an attorney signs off on a pleading or other document that is filed with the court, and that pleading does not have a basis in law or fact, or at least a good faith basis in law or fact, then the party who filed that pleading and or the lawyer can be sanctioned in terms of perhaps having to pay the attorney fees of the opposing party. In addition, this investigation will enable the paralegal and attorney to help craft a preliminary roadmap for formal discovery if the suit is in fact filed and the case goes that far. So let's look here at the 5 basic sources of investigation for facts that have potential value as proof. We call those probative facts. The obvious first choice is the client himself or herself. And the client, of course, will be available to consult informally before the lawsuit is filed so that you can get as much information and documents as you can right away. Now, another source of investigation perhaps could be third-party witnesses. These are people who are not going to be parties to any lawsuit in the case, but they may have relevant knowledge or documents or other tangible things. Now, whether or not you can obtain information or documents from these witnesses before suit will simply depend whether they elect to cooperate with you, because most are not going to have a legal obligation to cooperate. So that will simply depend on their level of cooperation. Now, a third source of probative facts is exhibits, meaning tangible items of evidence. That would include documents. That would include photographs. That would also include any other physical things that might be used as evidence at trial. Now, again, whether or not you can obtain these items before suit informally will depend on who possesses the exhibits. Now, if it's the client that possesses the exhibits, then of course you have access to those right now, informally. Now, if it's something that is in the possession of someone or some entity under your client's control, then you also will be able to get them informally before the suit is filed, such as medical records from your client's physician, or tax records from your client's CPA, or if your client is an employer, information or documents from your client's employees, because your client would have the legal right to compel that third party to provide the information. Cell phone records belonging to your client would be another example. But if the exhibits are in possession of third parties that are neither your client nor someone under your client's control, then you're kind of at that person's mercy as to whether or not that person will voluntarily cooperate with you. Now, a fourth category of sources of information is experts. Now, experts we will look at a little more in detail later in this lecture, but many times in cases that involve particularly technical areas like medical or engineering, or other areas that the layperson will not likely have information about, then the other parties may call expert witnesses. And those experts will be sources of information and opinions. Now, if your client or your firm on behalf of your client retains an expert, such as a medical expert or so forth, then obviously you will have access to that expert's information and opinions and so forth. Now, if the opposing party retains an expert, then you will not have access to that expert now before the suit, unless the opposing party happens to voluntarily forward you, say, an expert's report in an attempt to reach a settlement. Now, there is a third category of experts we'll be looking at called non-retained experts. And we'll look at those again in more detail, but in general, non-retained experts are people that neither party retained, but were personally involved in the underlying events. And so it might be the plaintiff's actual treating physician. And whether that person will cooperate will depend on legally whether or not that person can without the patient's consent, or if it's a non-medical expert, it may just depend on whether they are willing to cooperate. But we'll look at experts in a little more detail. Now, the fifth and final source of investigation, of course, is the opponent of your client, the person that your client potentially may sue. Now, as you can imagine, generally, the opponent is not going to be willing to give up much, if anything, informally before a suit is filed, unless it is simply voluntarily provided in an attempt to reach a settlement or to try to persuade your client not to file the lawsuit. But generally, your opponent's not going to cooperate. That will have to wait until formal discovery in the lawsuit, when you can require your opponent to provide information and other documents. Now, let's look at the goals of the pre-suit investigation. And that will depend on whether or not your client is going to be a potential plaintiff, that is to file the lawsuit, or whether your client is someone who is being threatened with being sued as a defendant, or perhaps has already just been sued. So if your client is a potential plaintiff, here are the key goals of the investigation. First of all, you obviously want to find out as much information as possible about the incident or dispute that is involved in your client's matter, including all potential witnesses and all evidence that may be out there. In addition, you want to identify the nature, extent, and dollar amounts of all injuries and damages that the potential client has sustained, because these are potential damages that the client may be able to seek recovery for in the lawsuit. Now, in addition, or perhaps instead, you will want to find out, is there any appropriate equitable, that is non-monetary relief that your client may be entitled to in the lawsuit, such as an injunction, a court decree against the opposing party, forbidding that party from taking some action. Now, of course, in gathering all these facts, you're ultimately going to want to find out which of those facts, if any, would support a recognized legal theory that, by combining the facts and legal theory, would give your client a cause of action and thus a legal justification for filing the suit. Now, another aspect of a cause of action is that you're going to want to find out what is the deadline, if any, for filing suit on that cause of action. And we're going to look at two legal mechanisms that operate to limit how long a plaintiff can wait once the plaintiff has a cause of action to seek that remedy before the plaintiff will be barred from doing it. A plaintiff cannot sleep on his or her rights too long. And so the mechanism will depend on whether their client is seeking legal remedies, that is money, or whether the client is seeking equitable remedies. If the client is seeking a legal remedy, then there will be an applicable statute of limitations that will impose an exact fixed time limit beginning the day after the cause of action arose or accrued for the client to file suit. And if the client misses that deadline by even one day, the client's claim is barred. Now, if it's an equitable remedy the client is seeking, its statutes of limitations do not apply to those remedies, but instead the common law doctrine called laches may operate to bar the suit. If out of fairness to the defendant, it would be unfair to grant the equitable relief given the delay the plaintiff has taken in seeking that relief. But we'll look at these time-barred issues a little bit later in the lecture. Now, finally, a plaintiff's lawyer is going to want to know, is the potential defendant whom the client may sue judgment-proof? That is this a defendant who's not covered by any liability insurance or doesn't have sufficient liability insurance to cover the damages that you anticipate your potential client would be entitled to, or a defendant that does not have enough personal assets that would be non-exempt under the law from being subject to seizure and sale at public auction to satisfy any judgment that your client may obtain against the defendant. In other words, especially if your attorney's taking the case on a contingency fee basis, where your attorney's fees will be calculated as an agreed upon percentage of your client's actual recovery, well, your attorney's going to want to have some assurances that if the client wins the case, that there will be someone to pay the recovery. Otherwise, you just have a judgment on a piece of paper that is worth about what that piece of paper is worth. So this will be an important consideration for attorneys who take plaintiff's cases on contingency fee bases. Now, the attorney may not care if the attorney is going to be paid on an hourly basis, but then that might make it difficult for the client. But in any event, whether or not the defendant is judgment proof is something that the plaintiff's attorney will normally want to know. So those are the goals for investigations when the client is a potential plaintiff. Well, what about if a client is a potential defendant, who is someone who is either being threatened with a lawsuit or in fact has just been sued? Well, let's look at those goals. First of all, you're going to want to find out, is there any liability insurance that would cover this particular client's defense costs, attorney fees, or that would be required to fund any judgment if this defendant client were to be to lose at trial? Does this potential client have any automobile liability insurance if it's a car wreck related case? Are there liability? Most homeowner policies and renters policies will also have liability portions if there were injury that occurred on the premises and sometimes off premises. Is there any kind of commercial general liability policy if your client is a business owner? So there are lots of possibilities out there because your client may not have to pay you out of pocket if there is insurance that might cover your fees or that might pay at least another lawyer to represent this defendant and pay any judgment that that may be entered against this defendant. And you want to make sure that any claim for coverage under any of these policies is made as soon as practicable, because a lot of policies require the policyholder to notify them if the policyholder has been sued as soon as practicable, or otherwise there's a risk that the carrier may deny coverage on the grounds of late notice of claim. So you definitely want to get on that right away. Now, another goal for a potential defendant client is to obtain as much information as possible about the incident or dispute, including all potential witnesses and evidence, just as with a potential plaintiff. But here, you're going to want to also try to ascertain, are the allegations against the potential client true? Is there merit to these allegations? Or Does your client dispute? Is there conflicting evidence that would suggest the allegations at least are not true or arguably not true? In addition, you're going to want to ascertain, does your client have any affirmative defenses to the allegations being made against him or her? Now, an affirmative defense is a matter that if the defendant properly pleads it in his or her answer and proves it by a preponderance of evidence at trial, would legally absolve the defendant of any liability, even if the plaintiff can prove all the elements of the plaintiff's cause of action. Here are some examples of affirmative defenses, and there are many others. But, for example, if the plaintiff waited too late to seek legal remedies, that is, money damages, and the statute of limitations period had expired, then even if the plaintiff can prove all the elements of negligence, the defendant still wins because of the affirmative defense of statute of limitations. Again, the plaintiff has the burden to plead the defense and to prove the elements of the defense. Secondly, if the plaintiff were seeking equitable relief and the defendant pleaded the defense of laches, arguing that it would be now, because of the delay plaintiff took in filing suit, and circumstances have changed such that it would be extremely unfair to the defendant now to grant the relief that the plaintiff is requesting. And another example is if the plaintiff failed to mitigate his or her damages flowing from whatever wrongdoing the defendant allegedly did. Under the doctrine of mitigation, a plaintiff is required to at least take reasonable steps to try to minimize or reduce the harm flowing from the wrongdoing committed by the defendant. A classic example of this would be if the defendant breached an apartment lease, moved out early, and rather than attempting to re-let the apartment, the landlord just let it sit for empty for the full 6 months remainder of the lease, and then tried to seek the full 6 months rent from the defendant. Well, the landlord would be under a duty to at least take reasonable efforts to mitigate the damages by trying to find a substitute tenant who could pay rent and thereby reduce the liability of the old tenant under the contract of lease. Now, another goal for a defendant client is to ascertain any possible causes of action that defendant may have against another party in the case. When a defendant is sued in a lawsuit, there are times when the defendant himself or herself may have an actual cause of action, meaning wanting to seek some kind of remedy against another party instead of simply just denying the allegations and defending himself against the plaintiff's allegations. So here are two examples of types of causes of action that a defendant may assert against another party in the case. A counterclaim, for one, is a defendant's cause of action against the plaintiff who has sued him or her. And that cause of action is asserted by the defendant in the same lawsuit. A second example is a cross-claim. That is a defendant's cause of action that the defendant has against another defendant in the lawsuit, and that is asserted against that defendant in the same lawsuit. This happens, for example, in car wreck cases. The plaintiff, hypothetically, sues two defendants for causing a car accident that involved all three cars. And the plaintiff alleges that they caused the damage. Well, one of the defendants may believe that, in fact, the accident was the plaintiff's fault, and that defendant may want to sue the plaintiff for negligence and try to recoup any personal injury damages and property damages that the defendant had sustained. Similarly, if one of the defendants believed that the accident was all the fault, or at least partially the fault, of one of the co-defendants, the other defendants in the case, then that defendant could file a cross-claim seeking for negligence against the other defendant to seek compensation for the personal injuries or property damages that that other defendant caused. So these are examples. You'll just want to find out, is there a potential cause of action that this client, even though a defendant, would have a right to assert against another party in the case? Okay, well, let's start walking through now the 4 of the 5 basic sources of probative facts. Again, the very last one we looked at was the opposing party, but again, in a pre-suit investigation, normally the opposing party is not cooperative, and that normally is not something that is feasible. But we are going to look at the first 4, and the first obvious choice for a source of information is your own client. And we're going to talk about now how you conduct client interviews. Now, we're going to pretend here that you are conducting the initial client interview. Some firms have paralegals do the initial interview by themselves. Sometimes the firms will have both the lawyer and the paralegal together at the initial interview, and some firms will, prefer that the lawyer do the interview first. But in any event, we're going to treat this as if you, the paralegal, will be conducting the initial interview. So let's just walk through the process. Obviously, you need to schedule the interview with the client, but ethically, you need to make sure that in the very first communication you have with the client, whether oral or in writing, that you identify as yourself as a paralegal. So there's no confusion about your role in the firm. Now, when you are contacting the client to schedule the interview, be sure that you specify for the client any paperwork or other items that that potential client needs to bring to the meeting. And if you do this over the phone, then you'll want to send a confirming letter right away or a confirming email to the client to confirm the date and time and location, to list out the paperwork that needs to be brought, and give any directions to the office, parking instructions, and so forth for the client's information. Now, be sure you allocate enough time for the interview so you won't be rushed. And if the interview will not take place inside your own office, that is your own personal space in the firm, you'll need to reserve a conference room or use another office or other quiet location to conduct the interview. Now, to prepare for the interview, you may at this point know what the client's case is basically about. Like, you may know that it has to do with a car wreck, or you may know maybe the client got injured because he or she fell on a hazardous condition at a grocery store. Or it may be that your client's in a dispute with someone with whom your client had a contract. So if you know generally what your client's case is about, but are unfamiliar with the basic law relating to that type of case, it's good to briefly research the basic principles of that law, so that will give you an idea what types of facts will be most relevant that when you are interviewing the client. Now, if the client's case involves subject matter that you're unfamiliar with, such as some kind of particular medical condition, or your client may have a defectively constructed foundation in your client's house, and you are not familiar with that topic, it's a good idea to do a little bit of non-legal research online or in other non-legal resources, just to brush up on the basic concepts and terminology of the subject matter, so that you can speak to the client more knowledgeably and will also help focus your questions better. Now, you'll also want to prepare an interview checklist or some kind of outline to kind of guide your questions during the interview to make sure you cover everything that's relevant. Now, your attorney may have a checklist or outline that your attorney wants you to use, or a questionnaire. So you'll be sure to ask your attorney if he or she or the firm has anything you can use to go by. Now, the topics you'll need to ask about, of course, will vary according to the nature of the client's case. Now, if you need additional assistance in crafting an outline or checklist, there are some sources. If your firm does not have one, there are commercial practice guides out there. If you have access to Westlaw or Lexis, there will be in the practical law sections on those online legal research resources various practice guides. It'd be good for you to go to one that relates to the jurisdiction you're in, such as Texas. If it's a Texas cause of action, such as breach of contract or negligence. If it's a federal cause of action, such as a Title VII violation under the Civil Rights Act, then you'll want to go to a federal resource practice guide for a checklist there. So you're not thrown to the wolves. There is help out there, but your own law firm and attorney will be the first point to check for guidance on how you should structure your outline. Okay, let's say you've got your client or the potential client at the office. Now, one of the key things you want to do in an initial client interview is to establish rapport. That is a good working relationship where the client begins to trust and have faith in you as a representative of the firm, and as someone that your client is glad to have hired or hopes to hire if it hasn't been sealed already. So when the client arrives at the law firm, it's good not to make the client wait in the reception area. Preferably, it's good to personally go out to the reception area, greet the client, and then invite the client back either to your office or the conference room, wherever the meeting is going to take place. And even if the client's early, at least the client can go ahead and make himself or herself comfortable in the area where the interview will take place. And before you get started with the interview, it helps to engage in a little small talk about the weather or whatever topics, just to make the client feel more comfortable and relaxed. It's good to offer the client some kind of refreshment like water, coffee, or a soft drink. And it will make the client feel much better if you refrain from taking cell phone calls or texting during the interview regarding other matters. Now, should you or should you not record the interview? Now, you'll want to take notes in the interview, but recording is a little bit of a tricky thing. If you really want to audio record the interview, you need to ask the client's permission first. Now, if the client refuses, don't record. But even if the client kind of acquiesces, but seems hesitant or a little bit uncomfortable with it, don't record. Because if your client has any reservations about it, your client will be less likely to be fully forthcoming, and you don't want that. You want to get as much information from the client as possible. Now, you yourself will need to take notes. I recommend taking notes by hand rather than taking them on a laptop or tablet, because when you're buried in an electronic device, you're not making contact with the client. The tapping of the keys on a laptop can be irritating and distracting. So preferably take notes by hand, and if at all possible, try not to take a bunch of notes by hand at the very beginning of the interview. At the beginning is when you're really trying to make the connection with the client, make eye contact, and if all you're doing is buried taking notes, trying to take down every single word the client is saying, then that will not help build a good rapport. Now, here is a basic suggested structure for the interview. Now, this can vary, and your attorney may have different goals or different ideas, but here is one suggestion. And that is to divide your interview essentially into basic phases. At the very beginning, it is good to let the client talk. Let the client tell his or her story in his or her own words. A lot of times clients need to vent because they're frequently upset about what their opponent has done and how they feel aggrieved or injured. So let the client tell the story in his or her own words. And you can prompt this by asking open-ended questions to the client. And open-ended questions are simply questions that invite the client to give narrative answers in his or her own words. For example, you could say, "So tell me what happened." Well, that is a very open-ended question that is inviting the client to start talking. Or what happened that day? Or how did the accident happen? These are open-ended questions because and the client will then hopefully get the sense that the client is free now to start telling you his story or her story in his or her own words. Now, once you have, as you can imagine, clients can digress. They can bounce from one topic to another. It will not, and it will probably not be in any kind of uh, regimented chronological order. So what you do is after the client has given his or her story in his or her own words, then you're going to want to back up and go back through the story chronologically. That is, in the order in which the events actually occurred. Make sure you understand the exact order in which things occurred, the dates on which they occurred, and try to go back and fill in any gaps in the story that the client may not have given, or that where you have questions that you need filling in. Now, here you can include more focused questions, such as closed-ended questions, which are simply questions that call for a yes or no answer, but that don't contain or suggest the answer that you want or expect. So if you asked the client, did you go to work that day? Well, the answer would be yes or no. You're not suggesting what you think the answer should be or what it ought to be. You're just asking for a fact. That helps focus the questions and fill in gaps. And you could also, on occasion, use some leading questions. And those are questions containing or suggesting the desired or expected answer, and basically just ask the person to assent to that proposition. So a closed-ended question would be, did you go to work that day? And it would call for a yes or no answer. A leading question format would be, you went to work that day, correct? And so then the client would simply agree or disagree with your statement. And so this is one way to help get more detail, clarify any ambiguities, and make sure you understand the exact chronological sequence of events. Now, after you do that, then the third stage of the interview would be to follow up with questions that explore potentially unfavorable facts to the client's case. Or if after hearing the story and clarifying chronologically what happened, if you find that there are some holes in the story, if there are things that don't make sense, or if there are questions that need answering to determine whether or not there's some landmines hidden in the facts here, you need to ask them, because you need to find out all the facts that are relevant to the client's case, whether they help the client or whether they hurt the client. And you can explain to the client that you need to know all the facts, good, bad, and the ugly. And so the client won't be offended, such as if it's a car wreck case, it's a fair question to the client to say, for example, were you using your cell phone at the time of the accident? Or had you been drinking that day before the accident? These are things that, you could say, I'm asking because the opposing lawyer in the case would likely ask you this in a deposition, and so we just need to cover all of this now. Now, after you do that, it's always good to find out what is the client's expectations in the case. What does your client want your law firm to do for him or her? Does he or she want to get money? If so, how much money would your client consider a win? Or how much money would your client be happy to receive? Now, you're in no way going to be guaranteeing that the client is entitled to any of this. You can't. If you're a paralegal, you can't give legal advice. But it is good for your supervising attorney to know what the client's expectations are, and you can simply ask your client. Of course, you don't tell your client whether or not your client's going to get that. That needs to come from the attorney, but you can certainly ask the question. And then you're going to want to get some basic client background information. Where'd the client go to school? What degrees does your client have, if any? Is your client married? What's the name of your client's spouse? Where is your client employed? What's your client's employment history? Has your client ever been sued or sued anyone in civil court before? Does your client have any criminal backgrounds, any criminal convictions? You need to know that up front, because if there are felony convictions or serious misdemeanor convictions within the last 10 years, then that's something that could play a role in the lawsuit. Also, you want to ask your client, did your client, and I say potential client, did that person consult any other attorneys regarding this same matter, or hire any attorneys in the past regarding this same matter, or has this client ever sued on this same matter before? Also, you'll want to be sure to obtain all of the client's current personal and business contact information, including an emergency contact, such as the client's spouse or relative or somebody like that, in case the firm needs to get in touch with this person right away and you can't get the client through the normal channels. Finally, you'll want to let the client know about any additional information or documents or materials that the client didn't bring to the interview but needs to. And depending on whether your attorney wants you to do this at this point or not, you could go ahead and have the client sign a medical records authorization if it's a personal injury suit, so that your firm can present that authorization directly to the client's physicians or other healthcare providers and obtain the client's medical records directly. Or if it's the suit involves lost wages or diminished earning capacity, then you might have the client sign an employer records authorization, which would authorize the employer to provide directly to your law firm relevant employment records to prove up those injuries or damages. Now, after the client interview is done, you're going to want to immediately prepare a summary of it. Now, your attorney may have a format that your attorney wants to use, but it could just be on a Word document. It may be in an email to the attorney. It may be on a form that your attorney wants you to use. But you'll want to prepare a summary. And in addition, you'll want to collect all of the original documents that your client brought with him or her and place them in a separate file folder in the firm where they will not be damaged or altered, because they may need to be used as original exhibits at trial ultimately. If your client wants a copy of those for your client to keep at home, then your firm can make those for the client, but the firm needs to keep the originals. Now, after this initial interview, it may be that before the attorney decides to take the case, or if the attorney decides to take the case but before the lawsuit is filed, you may have to conduct a couple of follow-up interviews to get additional facts that you need, or to review any additional documents or information your client may subsequently provide. And then if the lawsuit is filed on behalf of the client, then there will be many follow-up contacts and interviews throughout the litigation, such as to obtain information and documents that you need to respond to discovery requests received from other parties. Or you might need to get your client's signature on affidavits or sworn discovery responses in the discovery process. And if your client's deposition is going to be taken by the opposing attorney, or if the case is going to go to trial and of course your client will have to testify, then you'll have to meet with the client to help prepare your client for those proceedings. Okay, so that is an overview of how to conduct a client interview. Now let's look at the second big source of probative facts, and that is third-party witnesses. That is, people who have potentially relevant information or documents, but that will not ultimately be a party to the lawsuit. And so in determining which witnesses you need to interview, it's a good idea to talk to your supervising attorney, because your supervising attorney may have certain ideas about which witnesses should be interviewed and which ones we don't really need to worry about until maybe after the lawsuit's filed, if even then. You'll also want to consult with your attorney about the order in which to interview the witnesses that you've chosen, and make sure that you know from your attorney any specific information that your attorney especially wants you to try to obtain from these witnesses. We're going to go over the basics of what you need in general terms from witnesses, but your attorney may have a very specific thing in mind that you want to be sure is put on your checklist or outline. Now, it can be a challenge when trying to set up witness interviews if you don't know where the witnesses are, or if the contact information you have for them is no longer valid. So here are some sources for trying to obtain the latest contact information for third-party witnesses. The first choice would be to go to your client and see, does your client have any information about the witness's whereabouts, or at least what is the latest information your client may have. You can also get on the internet, and there are certain sites that are particularly good for helping to locate individuals, like Anywho, Yahoo People Search, just a general Google search, Zaba search. These are just examples. There are lots of people search sites out there. You can just browse the internet and try to find a resource that has the latest information on the witness's whereabouts. Now, in difficult cases, the firm can retain a private investigator who can really dig deeply to try to locate the witness. And if you happen to know the identities of any family, friends, or neighbors or coworkers of the witness, you might try reaching out to those persons to see if they could provide any information about the witness. Now, there are public records that may help you, such as incident or police reports relating to an accident that may have that information. You could also search online court records to see if that person has ever been a party to a lawsuit, particularly if that person is represented himself and didn't have a lawyer. Then that information might be on the court records. Now, if the person owns real estate in a particular county, you could get on the internet and look at the website for the county tax assessor's office and search by owner name and see if you could pull up the person that way. If the person's licensed, such as an electrician or a plumber or a doctor or a lawyer or an engineer, you can go to the websites for the appropriate licensing agencies, look up the person by name, and you may be able to find the person's address or other contact information on those sites. And of course, the old-fashioned phone book is still a possibility. Now, once you have located the witness, during your first contact with him or her, you need to identify yourself as a paralegal. Make sure you do that. You don't want to leave the impression you're an attorney. Second of all, identify whom you work for, such as the law firm name and the attorney who is specifically supervising you in this case. And you want to identify for the witness whom your firm represents, or at least potentially represents, so that the witness will know exactly who you are, who you work for, and who your firm's client or potential client is. Now, remember that third-party witnesses, before a suit is filed, have no legal obligation to cooperate with you and give an interview. But there are certain things you can do to try to maximize the chances of the witness cooperating. First of all, try to accommodate the witness's schedule as much as possible. If it's too difficult for the witness to make it to your office or wherever it's going to take place, the witness will be less likely to cooperate. Also, try to arrange for a location that's convenient for the witness. If your office is in downtown Dallas and your witness is up in Sherman, try to make arrangements to meet the witness somewhere, say at a Starbucks or anywhere that it would be appropriate to be able to sit down and talk, preferably somewhere that's relatively quiet so that you won't be too distracted. But the more you cooperate with the witness in the time and location, the more likely it is you will get cooperation from the witness. Now, one thing you might say, but only if your supervising attorney pre-approves you saying it, is to tell the witness that if the witness gives an interview now, it may eliminate the need, or at least decrease the chances of needing the witness's formal deposition later if the lawsuit is filed. Now, that some witnesses witnesses would certainly prefer to just give an informal interview than to later have to be placed under oath with a court reporter and be grilled by all the attorneys in the case outside of court, which is what a deposition is. But do not tell the witness this unless you have permission from your attorney, because it may be, even if the witness gives an informal interview now, a deposition may still be necessary down the road. So you want to be careful about promising or making it seem too sure that the witness will not have to be involved later if that is not necessarily going to be the case. Now, if usually you will schedule this over the phone when you're making your initial contact. Whether or not to send a confirmation letter after the phone call or an email will depend on your supervising attorney's instructions. Some attorneys like to minimize paper trails when you're dealing with third-party witnesses, because everything you say and all communications between your office and the witness will be discoverable by your opponent in the lawsuit. So be careful about sending confirmation letters, even though they sound innocuous and it's simply very straightforward and factual. Make sure you do it only if your supervising attorney wants you to do so. Now let's talk about the basic goals of an interview of a third-party witness. Now, of course, they're going to differ depending on the type of case involved. But here, these goals will pretty much apply to any type of case. First of all, you're going to want to learn everything that the witness knows about the client's matter, including any relevant documents or other items, and including any names and contact information of any other witnesses that this particular witness knows of. But you're also going to want to try to get a sense of what aspects of the case this witness does not know about. So you're essentially going to want to try to get everything the client knows, but also get a feel for the scope and limits of the witness's knowledge. In addition, from among all the statements that you're going to be given by the witness during the interview, you're going to want to distinguish among those statements that are based on what the witness personally observed and witnessed firsthand versus statements based on information the witness obtained secondhand, that is, from other people. And finally, you're going to want to be sure that you pinpoint those statements where the witness is simply speculating or guessing, because the witness does not know for sure. These are three characteristics that you need to see which of all the statements, in which of these three categories do the statements fall. And these are things you'll want to tie down with the witness. You'll also want to find possible ways of impeaching or discrediting the witness's credibility if the witness makes statements that hurt your client's or potential client's case. And here is a list of some of the basic ways that a witness can be impeached or discredited. If the witness is making statements that are based on secondhand information instead of what the witness personally observed or perceived, or if the statements of the witness are based on speculation or guesses. You'll also want to find out if the witness has any relationship, such as is the witness related to any of the potential parties in the case? Is the witness a good friend or a longtime friend? Is the witness an employee or have some other relationship with the potential parties in this case that might bias the witness either against your client or for your client's opponent because of this relationship? You'll also want to ask the witness if he or she has been convicted of a felony or serious misdemeanor within the last 10 years. Serious misdemeanor in Texas would mean like a crime of moral turpitude, especially theft and fraud, that sort of thing. And also if the witness has pleaded guilty to any such offenses within the last 10 years, because the evidence of that may be admissible by either side to try to impeach the witness's credibility. Also, are there internal contradictions within the witness's story? A witness can be discredited if their story is so internally contradictory that it doesn't make sense. It could also be discredited if the witness's story is externally contradictory when compared to your client's story, for example, combined with other facts obtained from other sources. So these are the most common ways that a witness can be discredited. So if the witness's testimony hurt your client's case, you'll want to probe in your questioning whether or not any of these grounds for potentially impeaching the witness might apply to help reduce the damage that this witness would do to the client's case. But on the flip side, even if the witness has things to say that may hurt your client, you'll want to see what facts, if any, that help your client that the witness can actually confirm. Or, as we say in the legal world, corroborate. So try to find out any facts that help your client that this witness may be able to corroborate, and that would at least help a little bit. Now, in addition, ask the witness to identify all persons or entities that the witness has discussed the case with, even for just a little bit, and what was said or written. For example, has the witness ever spoken to your client? Has the witness ever communicated with the opponent or the opponent's attorney? Has the witness ever communicated with any insurance company? And has the witness ever communicated with law enforcement? And find out what was said in what form, because these are things that you may need to try to get in formal discovery if the lawsuit is filed. Also, find out whether the witness has any plans to leave the state or country in the near future. If the witness is planning on taking a 6-month trip to overseas, or plans to move out of the country where the witness may no longer be in contact, you need to know this, because if the witness helps your client, then right after the lawsuit is filed, or maybe even before, which is allowed in some narrow circumstances, you might need to take the deposition of the witness to secure the witness's testimony for trial. But while you are interviewing the witness, you want to be sure that you're not so buried in taking notes that you fail to observe the witness's body language and other nonverbal cues. This is extremely important because overall, in addition to getting all this information, you want to get a sense of whether this particular witness would make a favorable, credible impression on a judge or jury if that person were to testify at a trial or hearing. And this is very important because the witness may hurt your client but not make a good impression. Or conversely, the witness may really help your client and make a bad impression, or could hurt your client and make a good impression. So you need to know, is this someone that a jury or judge would be likely to believe? What's the person's demeanor, meaning facial expressions, body language? Does the person seem nervous or uptight or evasive or tight-lipped? Or combative. You really try to make careful observations and not get so buried in taking notes that you fail to notice these details. Okay, so in preparing for a witness interview, you'll need to review your firm's case file, and that would include the interview notes, incident reports, and notes from many other witness interviews you may have conducted. Also, if you intend to use and show the witness during the interview any diagrams, photos, or records, you'll want to make a copy of those for use during the interview. And then you'll need to decide whether you want to try to record the interview, and if so, how. And I also highly recommend that before the interview, you get online and research the witness's online presence. That is the digital shadow. Look at social media sites like Facebook, LinkedIn, check out blogs, do Google searches to see what pops up about this witness, because it may give you vital background information or other information that will assist you in preparing for your questioning. Now, when you actually conduct the interview of the witness, you'll follow the basic same structure of that you followed for the initial client interview. Now, as we'll mention a little bit, just remember, though, that the witness is not your client, so there's no attorney-client privilege in what you say. But again, the structure will be roughly the same. Now, you'll want to be sure to stay neutral and objective regardless of what the witness says. If the witness's answer shocks you or hurts your client or really helps your client, or if it embarrasses you or even repulses you, don't let it show. You need to keep a poker face. You need to stay neutral, objective. Do not appear judgmental. Don't let on whether or not what the witness is saying is helping your client or hurting your client or somehow affecting you in a certain way. Now, if the witness answers questions with broad generalities, you need to be sure to follow up with questions to tie down the witness on the specific facts underlying those generalities. Here's some examples. If the witness describes some driver as having driven fast, well, that's really vague. The follow-up question should be, well, how fast was this person driving? Or if the witness says something about a person being drunk, well, again, that's a very general statement. So you might follow up with a question like, what did he do to give you the impression he was drunk? Or what was it about his appearance that gave you that impression? So that will then force the witness to start being more specific and give facts rather than these broad generalization conclusions. You also want to be sensitive to your choices of words in the question, because the choices of words you use in your questions can sometimes influence the response you receive. For example, never begin a question of a witness with saying something like, do you happen to remember whether the driver was wearing his seatbelt? Or do you know whether the driver was wearing his seatbelt? Or did you see whether whenever you begin a question like that, you are basically inviting the witness not to remember or not to know or not to have seen. It's giving the witness an out. So instead, just ask the question directly. Was the driver wearing his seatbelt? And if the witness wants to say, I don't know, I didn't see, fine. But you don't want to invite the witness or remind the witness that not remembering might be an option. So ask the question directly. In addition, if you ask questions in a leading format, you're more likely to elicit a yes response than in a non-leading format. Also, depending on how you word the question, you could influence the answer. It's kind of the glass half full, glass half empty issue. If you ask, for example, how fast a car was going, as opposed to how slowly a car is going, the witness may give an answer indicating the car was going faster than if you had asked the question the opposite way. Also, one thing you might do is if you've already interviewed witnesses who have told you a particular fact and it helps your client, you could tell that witness that you're currently interviewing that you have spoken to other witnesses and they have said XYZ. And you know in your mind that helps your client. Now, once your current witness hears this, the current witness may be a little nervous about contradicting that. And so the current witness may be more likely to give an answer that's consistent with what you've said other witnesses have said. Now, again, carefully observe the witness's body language and other nonverbal cues. Is the witness evasive, nervous, tight-lipped? And again, you're going to want to, at the end of the day, to try to make an assessment for your supervising attorney. Would this person make a favorable, credible impression on a judge or jury? But here is a big caution about interviewing third-party witnesses. Because this witness is not your firm's client, any communications that you or your attorney or anyone else from your firm have with this witness, whether they're oral or in writing, are not protected by any attorney-client privilege. So later on, if the lawsuit's filed and the opposing lawyer takes the deposition of this witness or sends other discovery that would probe into communications your firm has had with this witness, that opposing attorney will be able to learn of all the communications that you had with this witness. The witness would be required to tell the attorney everything you said to the witness. So for this reason, you need to be very careful not to reveal to the witness any confidential or privileged information or make any other statements that you would not want the opposing lawyer in the upcoming lawsuit to find out about. So just be very, very careful. This isn't your client, and that witness may be forced to divulge or could voluntarily divulge to the opposing lawyer every single thing that you've said. Now let's get to the issue of recording the interview. Now, there are various methods for recording in its broadest sense. I mean, the most obvious is you take notes during the interview by hand, preferably, as opposed to a laptop or tablet. Another way is to obtain a signed witness statement after you've interviewed the witness. For example, if the witness is there at your office right after the interview, you could go to your office, type up a quick summary of the interview, print it out, have the witness review it, and just simply sign it, to say, yeah, this is my story. Now, if your attorney would prefer this to be under oath, then you could prepare instead an affidavit for the witness to review and sign. And now an affidavit is something we'll be looking at in more detail later in the course, but it's simply a written statement by a witness made under oath and acknowledged by a notary public. So the witness you would type up the summary of the witness's story, or the key parts of it, and in the format of an affidavit, and then you would need to have a notary public present to witness the witness signing the affidavit, and the notary public would need to stamp it and sign it and date it also. Now, yet another option is after the interview, you could prepare a confirming letter to the witness, summarizing what the witness said in the interview and requesting the witness to review it, sign it, and return a copy of the letter with the signature to acknowledge its accuracy. Now, this is not to say that any three of these witness statement formats would necessarily be admissible in evidence at trial. So you'll want to be sure that to know what your supervising attorney would like you to do in terms of getting a signed witness statement, if any. Now, one option you could use is bring a court reporter to the interview. Now, a court reporter is also known as a stenographer. That is the person who you've seen it at least on TV, if not in a real courtroom, who sits at a little stenography machine and will take down every single word that the witnesses say and that the lawyers say while on the record at trial or a hearing. Now, there are court reporters that are not employed by the court, but instead are retained by lawyers outside of official court proceedings to depositions and also to record interviews. And so if you interviewed with a court reporter, the witness would not be sworn unless you ask the court reporter to place the witness under oath, although that might have a chilling effect on the forthcomingness of the witness. But the court reporter would bring his or her stenograph machine and take down every word that was said, and then afterwards prepare a written transcript, word for word, of everything that was said. Now, this is very good because you have an absolutely perfectly accurate word for word transcription of the entire interview. And especially if it's an unfavorable witness, where you really need to be more detailed to try to explore the weaknesses in the testimony, it is especially helpful. But there's some downsides to using using a court reporter. First of all, no matter if it's a favorable or unfavorable witness, he or she may not be real keen on having a court reporter there. First of all, it smacks of official court proceedings, and that might scare the witness. Second of all, the witness may be less likely to talk and far more guarded about what the witness says if he or she thinks that literally every word is being taken down verbatim. Another downside is that using court reporters is expensive. They charge for their time and they charge for the transcripts. And so using a court reporter may be cost prohibitive if your client and or your supervising attorney has uh, budget concerns about how much money will be incurred or expenses are going to be incurred in the case. Now, yet another option of recording the interview is an audio recorder. Now, if you want to audio record, such as with your cell phone audio voice recorder or some other voice recording device, ask for the witness's permission to record ahead of time. Now, if the witness consents to the recording, what you're going to want to do is make sure you document on the recording certain key facts. So right after you turn on the recorder, you're going to want the witness, while being recorded, to verify that the witness has given you permission to record the interview. And you're also going to want to do that at the very end of the interview, right before you turn off the recorder. Because you don't want any dispute down the road of the witness claiming that he or she did not in fact give you permission to record, because you don't want to run afoul of federal or state wiretapping statutes, which we'll talk about in a second. In addition, you'll want to identify the exact date and time on which you turned the recorder on, and then right before you turned it off, the exact date and time you're turning it off. Now, you should still take handwritten notes as usual, even though you're recording it, just in case the recorder malfunctions. That has happened before. And all of a sudden, at the end of the day, you realize you don't have a word that's recorded, and yet you didn't take notes. So it's still good to take handwritten notes. Now, if you're going to record it, be sure that if the witness wants to answer a question with the word yes or no, that the witness actually say the word yes or no. Because when you're audio recording, as opposed to having a video tape there or video camera there, shaking one's head or nodding one's head or saying uh-huh or uh-uh does not register on an audio recording. At least it won't register very clearly. And so to avoid any kind of dispute or ambiguity, if the witness answers a question by shaking or nodding her head or grunting uh-huh or uh-uh, ask the witness to restate the answer in a word so that it's clear. And finally, once the the interview is done, be sure you preserve the actual tape or the audio file of the statement carefully so that it won't be accidentally deleted or damaged, because it might, your attorney may want to listen to it later, you may want to listen to it later, or it might actually become potential something you would have to give up in discovery, or in certain circumstances, it might be even admissible at trial. So be sure you keep that. Now, I want to talk about this issue of wiretapping statutes. This is why you need to get the person's permission, and you want to make sure you have that permission documented on the actual recording. Each state, as well as the federal system, has wiretapping statutes. And these are essentially laws that govern when and under what circumstances an oral communication or a telephone conversation can be recorded by someone who's not a part of law enforcement. And there are basically two types of these laws nationwide. In Texas and in the federal laws, we have what are called one-party consent laws. These are one-party consent wiretapping statutes. And these are laws that permit someone who's not part of law enforcement to record an oral communication or telephone communication only if at least one party to the conversation consents to the recording. That's why they're called one-party consent laws. At least one participant in the conversation or communication has to consent. And if you're a party to the communication and you want to record it, well, that counts. And the other party doesn't know about it, that's fine, because you're one of the parties to the communication and you're recording it. Now, where you would run afoul of this is if you secretly record the conversation between two other people and neither of them knows that you are recording, or neither of them has consented to your recording. So in Texas and the federal laws, we have one-party consent wiretapping statutes. And this is serious business because in Texas, a violation of the wiretapping statute is a felony. Now, in some other states, there are instead two-party consent laws. And these are laws that would allow this recording only if both parties to the communication consent. Now, it would be safest always to obtain the consent of all parties to the communication. Otherwise, do not record. I think that is by far the safest thing to do. And because whether or not your particular situation is going to be governed by the Texas wiretap statute versus the federal, or if you're talking to someone, if you're in Texas and you're on the phone with somebody in another state, would that other state's wiretapping laws govern? This is where you need to be very careful and not just assume things. If you are ever in a position where you are thinking about recording an interview or conversation without the consent of all parties to that communication, first consult with your supervising attorney and do what your supervising attorney says to do. Do not venture out, because you certainly don't want to inadvertently stumble into a violation of a wiretapping statute. So by far the safest thing to do is simply obtain the consent of all the parties, and if any party refuses to give consent, then don't record. Otherwise, you need to consult your supervising attorney and talk about how you're, whether or not you should record without all people consenting. Okay, after the interview of the third-party witness, you'll need to prepare a memo to the file or direct it to your supervising attorney that summarizes the witness's statements, preferably kind of broken up into headings so that your attorney can know where to go and to find certain information. But you will want to specifically note and describe the witness's overall credibility, all statements that help your client's case and why, all statements that hurt your client's case and why, any suggested follow-up investigation that you think could be done informally based on information you obtained, and any suggested formal discovery that you think should be performed once the lawsuit is filed, such as taking depositions of witnesses or subpoenaing documents from third parties or other things you might want to get from your opponent in discovery. Also, if the witness's testimony or statements hurt your client's case in any way, note any methods of impeaching that witness, that is, attacking the witness's credibility at trial to try to limit the damage. Okay, so we've looked at client interviews, we've looked at third-party witness interviews. Now let's look at the third category of major sources of probative facts, and that is exhibits. Now, exhibits are simply tangible evidence presented at a trial or hearing, as opposed to oral witness testimony. Now, the most common categories of exhibits are photographs, diagrams, physical evidence, and documents and records. Now, in order for exhibits to be admissible in evidence, normally you will have to have a witness who can testify to certain key facts that establish the foundation for why the exhibit is admissible. And this is called foundation testimony. And the type of facts the witness would have to testify to will depend on the type of exhibit you're dealing with. So let's look at the first type of exhibit, photos. Today, many lawyers use as evidence at a trial or hearing photos that are in digital format and are projected on a TV screen or monitor. Now, the old-fashioned way, which is still used too, is to have the photos developed on paper, blown up to 8 inches by 10 inches, usually glossy, for use with the witness, and then the jury would ultimately be able to take that into the jury room. Now, to get a photograph into evidence, to make it admissible, you'll have to have a witness who can get on the witness stand and be shown the photo and then testify to what the photo depicts, that is what it describes, and the fact that the photo depicts that subject fairly and accurately as of the relevant date, such as the date the accident occurred. Now, the witness who testifies to the foundation does not have to be the one who actually took the photograph. It could, as long as the person can testify to what it shows and that it shows it fairly and accurately as of the relevant date, you're good. Therefore, a paralegal could go out to an accident scene, take photos without fear of having to be the witness to testify to these things. Normally, you would have your client or some third-party witness, or maybe even the opponent, if the opponent would admit these things. But the paralegal would not have to worry that by taking the photo, the paralegal was suddenly going to be injecting himself or herself as a fact witness to have to testify to the foundation at trial. Now, the second category of exhibits is diagrams, that is drawings, such as drawings of an intersection where an accident occurred, showing the contours of the street and the median and the lights and any obstructions. Now, the format for using diagrams at trial is commonly to blow up the diagram to the size of 24 inches by 36 inches. Now, to get a diagram admitted into evidence, you're going to have a witness, and that witness will have to testify to the same two things that the witness would have to testify for the photo foundation. That is, you have to testify to what the diagram depicts and the fact that the diagram depicts whatever it is fairly and accurately as of the relevant date. But for diagrams, there's a third possible required testimony, and it depends on whether it's disputed or whether your opponent brings it up. But the witness may also have to testify that the diagram is drawn to scale. That is, that the diagram is drawn in the identical proportions, just smaller, as the original of what it depicts. And if that is in dispute, then you're going to have that extra fact testified to. Well, because of this potential third requirement, normally a paralegal should not be the person to prepare a diagram. Instead, it should be a witness to prepare it who can actually get on the witness stand and testify to these three elements, including the requirement that it be drawn to scale. So those are the requirements for getting diagrams into evidence. Now let's look at the third category of exhibits, physical evidence. Those are simply tangible personal property, meaning not diagrams, not photos, but actual physical items, such as in a murder case, the murder weapon, a gun, a knife. And even in civil cases, you a lot of times have physical items. If you have a dispute about what caused the damage to a roof, you might actually have a cutout section of the roof covering as a physical evidence admitted at trial. Now, physical evidence, when you are trying to gather it, will basically fall into one of two categories. One is that those pieces of physical evidence that are readily available to your client or law firm, such as whatever debris happens to be around the scene of the accident along by the intersection. So if that's the case, then your firm or your client would have access to it now. You have to go out and get it, provided you acted quickly. But usually, though, a lot of the physical evidence will be in the possession of third parties. Again, remember, third parties are people or entities who will not be parties to the lawsuit. And this could include police departments, repair shops, engineering or chemical labs, and so forth. Now, let's look first of all at the physical evidence that may be available to your client or firm now. If so, as quickly as possible after the incident in question, you'll want to act quickly to locate the evidence, acquire it, and preserve it so that it will not be lost, destroyed, or altered before trial, such as sealing it in an envelope or a canister to prevent it from decomposing, or whatever might occur. Now, because of the time involved here, a lot of firms will hire investigators to go out and try to gather these items. And that way they can do that, and then the investigators can then get on the witness stand at trial instead of the paralegal and testify to the foundation to obtain admissibility. Now, on the other hand, if the physical evidence is in possession of third parties, well, you're back into the situation that you were in with third-party witnesses. Most third parties will have no legal obligation to cooperate with you by turning over the items to your law firm or allowing your law firm to inspect or take photos or whatever. But you can ask and see if the third parties will cooperate anyway. If they are not, make a note of it, because once the lawsuit is filed, then your firm can compel that third party to comply by serving the third party with a subpoena ducis tecum in discovery. Now, I think at this point I want to introduce the concept of the subpoena, because subpoenas are ways that in a lawsuit you can compel third parties who are not a party to the lawsuit to provide testimony at a trial hearing or deposition, or to provide relevant physical things or documents that the third parties might have. So a subpoena, which is a term that means in Latin under penalty, is a written command that is enforceable by the court in a particular lawsuit that a witness appear at a certain time and place and give testimony, oral testimony regarding a certain matter. And this could be either at a trial or a hearing or at a deposition. Now, if you're wanting the witness to provide physical things like documents or other evidence as opposed to just testimony, then there's a special type of subpoena for that purpose, and that's the subpoena ducis tecum. And ducis tecum simply means bring with you. And that's a written command, also enforceable by the court in the lawsuit, that a witness provides specified documents or other things regarding a certain matter. So you'll want to make a note of any third parties that are refusing to cooperate by giving you the items, because your attorney may believe that a subpoena ducis tecum is in order to be served on that third party once the lawsuit is filed. You'll find some third parties are not necessarily being jerks, but instead they may say, I can't do that, or I won't turn it over unless I receive a subpoena. And that's a common response that you'll get, and this is what they're referring to. And if there are third parties that have possession of potentially relevant evidence, sometimes attorneys will send these third parties what is called an evidence preservation letter, which is simply a letter by the attorney to the third parties notifying those parties that they have evidence in their possession that may be relevant to the litigation, and therefore they are under a duty to preserve that evidence. Now, if you have physical evidence that you want to get in evidence at trial, then again, you're going to have a witness to testify to the foundation. And so here is the foundation for physical evidence. The witness is going to have to testify to what the object is, also the object's chain of custody, that is, the history of who has possessed the evidence at all times since it was acquired from the scene until the very moment of the trial testimony. And finally, the fact that the condition of the evidence has not changed since its acquisition. So you have three basic requirements that a witness will have to testify to get a piece of physical evidence in evidence at trial. Now, just one practical note. If your opponent in the lawsuit does not object to the admissibility of any of this evidence, then even if you haven't laid the foundation through the witness, then the court will likely go ahead and admit it anyway. But it's always good to make sure you have a witness who can testify to the foundation, unless you have perhaps a written stipulation or agreement by the lawyer um, that he or she will not object to the admissibility of the evidence. Okay, now let's look at the fourth and final category of exhibits, and that is documents and other records. Now, as with physical evidence, there are going to be documents and records that are available to your client or firm now, and then there are going to be documents and records that are possibly in the possession of third parties. So if they're available to your client or firm now, you'll want to obtain all of them that your client either has possession of or custody of, or that your client has control over, even though they might be in the possession of third parties. So by control, I mean your client, though not personally having possession of them, has the legal ability to compel a third party to provide them without a subpoena. So this would include your client's medical records, your client's bank records, certain employment records from your client's employer, your client's cell phone service provider records, tax records from your client's accountant, because your client can call his or her own doctor, bank, employer, cell phone provider, service provider, or accountant and say, I need my records. Now, there may have to be a fee paid to get them, but your client can get them. So that's what we mean by control. You'll want to get all of those because those are all available to you and your client now. Now, in terms of getting medical records or employer records, a lot of law firms prefer that instead of having the client go get the records and then forward them on to the law firm, that the law firm be permitted to get them directly from the healthcare provider or the employer. And mainly it's just to make sure that the law firm is getting everything that's relevant. And so in this regard, to do this, the law firm will have to have the client sign a medical records authorization. Under federal and Texas law, healthcare providers are not allowed to disclose confidential patient information to just anybody that asks. Instead, if it's not the patient, then the patient will have to sign an authorization form allowing or authorizing the healthcare provider to release those documents to a third party like the law firm. And there are two basic laws that these forms have to comply with. The big one is the Federal Health Insurance Portability and Accountability Act, which strictly governs the confidentiality of patients' confidential medical information. That's also known by its acronym HIPAA, HIPAA. There's also a similar statute in Texas called the Texas Medical Privacy Act. So you're going to want to be sure that the form you ask the client to sign complies with HIPAA and the TMPA. Now, if you need to get employment-related records to document lost wages, missed work, and that sort of thing, then the employer will not normally give you the law firm records relating to the employee without an authorization signed by the employee. And so you would need to present an authorization for your client's signature so that your law firm can then present it to the employer and get those records directly. Now let's shift gears and talk about documents or records that are in the possession of third parties. Again, as with physical evidence, you can ask third parties for their cooperation in voluntarily turning over relevant documents or records that they have, or at least allowing inspection or allowing copies to be made. But again, most third parties will have no legal obligation to cooperate. So if they say no, or if they say, I'll only do it in response to a subpoena, then make a note of who these third parties are, what they supposedly have, and then you and your attorney can make the decision of whether or not a subpoena ducis tecum should be headed that person's way after the lawsuit's filed to force them to turn over the evidence. Now, some records that are relevant may be in the possession of government agencies or court clerks, and therefore are public records. You can get public records that are relevant now. You don't have to subpoena them from the agencies. Now, if you're going to file a Freedom of Information Act request with the federal government, that could take months, and that's a long, drawn-out process. But generally, if you're looking for documents that were filed in a different lawsuit, or bankruptcy records or criminal records, those are records that are, for the most part, public record, and you can get them easily from the clerk's office of the relevant court clerk. They charge a fee for the copies, but again, they're easy to get. Also, government agencies may have the records that you need. For example, if it's a car wreck case, you would definitely want to see any incident reports or accident reports prepared by the police department. And if you pay a little fee, they'll provide you with a copy of that accident report. Now, if you get public records, and at least if you think that there's a possibility you may need them as evidence at trial, it's a good idea to get copies of these records that are certified. You can get them certified or uncertified. Certified copies are copies of the public records where an authorized official of the clerk's office or the government agency will stamp each copy with a stamp certifying that it is a true and correct copy of the original that is in that office. And if it's a certified copy of a public record, then it is what is known as self-authenticating. That is, you will not need a witness at trial to testify to the foundation for admissibility the way you would with other types of evidence that we've talked about. Now, speaking of the foundation testimony regarding documents and other records, because they contain words or numbers or other symbols, that is, that are designed to communicate, the evidence that the foundation testimony is a little more complicated. So I'm going to defer that topic until we talk about evidence in connection with Chapter 9. Okay, let's look now at the final category of sources of probative facts that we're going to look at in this lecture, and that is expert reviews. Now, in some types of cases, the plaintiff will have to prove certain elements that is beyond a layperson's qualification to give. For example, if a plaintiff is suing a doctor for malpractice, among the elements the plaintiff has to prove is what was the standard of care that the doctor should have if the doctor had been reasonable exercised in performing, say, a certain procedure. Well, a normal layperson, even the plaintiff who was injured, will not have the education, qualifications, or experience to be able to testify to that. Secondly, that the plaintiff would have to prove that not only that was the standard, but also that the physician in this case failed to meet that standard. So in this situation, the plaintiff would need to have a qualified expert witness to testify to establish these elements. Now, an expert witness is a person with scientific, technological, or other specialized knowledge who will review the facts of the case and form helpful opinions about them for a party in anticipation of litigation or in preparation for trial. Now, sometimes if the plaintiff hires an expert witness, then in response, the defendant may retain an expert witness of his or her own to contradict the opinions of the plaintiff's expert, in which case you have what's called a battle of the experts at trial. And so all the experts will testify, and then it'll be up to the fact finder, either the judge or the jury, based on all the evidence, to decide which of the experts is more credible, if any. Now, let's look at the types of experts that there are. First of all, you have testifying experts, and those are simply expert witnesses who will testify at a trial or hearing, or are expected to testify at a trial or hearing. Now, of these testifying experts, there are two types. First of all, you have the retained testifying expert. And that is a testifying expert that a party specifically hires or retains to review relevant facts that the party provides to the expert secondhand after the facts had already occurred. And then the expert will review these facts and form expert opinions about them. So here, the expert does not have firsthand knowledge of what happened, but is simply reviewing the records and other evidence documenting what has already happened and is sort of forming a after the fact opinion about whether someone acted reasonably or whether a standard of care was met or whatever the topic of the expert opinion might be. Now, the second category of testifying experts is the non-retained testifying expert. Now, this is a testifying expert that neither party actually hired in terms of giving testimony at trial, but the expert does have usually firsthand knowledge of the facts because this is an expert that was personally involved on some level in the underlying incidents. And we're going to look at an example of this in a second. But non-retained testifying experts have firsthand knowledge of the facts because they were actually involved in the subject matter about which they will be forming expert opinions and testifying at trial. Now, in distinction from the testifying expert is the consulting only expert. And that is simply an expert that a party hires or retains for consultation purposes, but who will not be expected to testify at a trial or hearing. So consulting only means just that. The party is only consulting. The party is not anticipating or expecting that person to actually testify at a trial or hearing. Now, here's a chart that basically summarizes the key aspects of all of these types of experts at a glance. So as you can see very quickly, you have at the top testifying experts in the two types, retained and non-retained, and then you have consulting only experts. So very quickly, for testifying experts, if the expert was retained, then yes, the party was retained by a party for litigation, that is, hired for the purpose of the litigation in some way. Now, if it's a non-retained testifying expert, the party did not retain the expert for the litigation. Instead, this was an expert that happened to have been involved in the underlying incidents before the litigation came about and has personal knowledge of it. Now, for consulting only experts, yes, they are retained by a party for the litigation, either for consulting purposes. Now, let's look at the second question. How do these experts learn of the facts of the case? Well, if it's a testifying retained expert, that is someone who normally learns about it only secondhand, after all the events have occurred, and simply reviews records, documents, maybe will inspect some property after something's occurred, or photographs and that sort of thing, and will render opinions based on what the experts learned secondhand. By contrast, a non-retained testifying expert normally has firsthand personal knowledge of the facts by virtue of that person's personal involvement in the underlying incidents before the lawsuit was filed. Now, a consulting-only expert normally learns of the facts only secondhand. Usually by photographs, reports, and other documentation of what has already occurred, and then the consulting-only expert renders opinions purely for the consulting benefit of the party that hired the expert. Now, the next question is easy. Will the expert testify at a trial or hearing? Well, by definition, if it's a testifying expert, either retained or non-retained, yes, the expert will be expected to testify. But if it's a consulting only expert, no, the expert will not be expected to testify. And then, is the identity of the expert discoverable by the opposing party. And that would go not only to the identity of the expert, but also to being able to discover everything that the expert reviewed in forming his or her opinions and what those opinions are and his or her credentials and so forth. Well, if it's a testifying expert, either retained or non-retained, yes, the opposing party is entitled to discover all of that. But if it's a consulting only expert that is, someone who will not be testifying, then the opposing party is not entitled to discover the identity of that expert or any of the other materials. So let's look at examples of these very quickly. Here's an example of a testifying retained expert. That would be, for example, in a personal injury case, a non-treating physician, that is, a physician who never did treat the plaintiff for anything, but who, after the fact, was retained by the plaintiff's lawyer or the plaintiff to review the medical records that reflected treatment performed by other physicians and then form an opinion about the medical propriety of that treatment and then to testify to that opinion at trial. So a non-treating physician reviewing records of treatment that's already been given by someone else to the plaintiff and then forming opinions on that treatment would be an example of a retained testifying expert. Now here's an example of a non-retained testifying expert. This would be, for example, the treating physician of the person who was injured. So if the person who was injured went to the emergency room the day right after the accident, then that person would have the option of calling the actual emergency room physician to get on the witness stand as an expert and testify that the treatment he or she actually gave the plaintiff at the emergency room was medically necessary and the charges were reasonable in and around the county. And so this would be this would be a physician, an expert who would have personal knowledge of the underlying facts because he or she actually performed the services that are the subject of the expert opinion. Finally, what's an example of a consulting expert? It's essentially the same as the retained testifying expert. You would have, say, a non-treating physician who would be retained to review the medical records and other evidence of other physicians' treatment of the plaintiff and to provide opinions for the benefit of the plaintiff's lawyer and plaintiff, just for consultation purposes. But that consulting only expert would, by definition, not be expected to testify at trial. So how do you locate an expert? You may be asked by your attorney to try to find an expert in a particular area for potentially serving as an expert for the client. Now, usually your law firm will have a list of experts that attorneys have used in the past in certain areas. But if you need to go outside of that, or if your firm does not have any viable suggestions, you can go to professional organizations in the proper field, such as engineering societies, medical societies. You can go to court records from other lawsuits relating to experts to see what experts parties in similar lawsuits have designated. And if it went so far as to get close to trial, frequently those expert designations will be among the public record filings in the lawsuit. In addition, you want to survey, if you have a big firm, you want to survey all the attorneys in your office to see if any of them have ever used any experts in this particular area before. And sometimes you might call attorneys in other law firms who've handled similar litigation to see if you can get some suggestions about potential experts. You could also go to the faculties of colleges, universities, medical schools, and law schools. Their bios and contact information will be available in the faculty links on these schools' websites, and you can see what areas each one specializes in, and then contact them to see if perhaps that person could serve as an expert or might refer you to someone who could. In addition, in the Texas Bar Journal, which is the official magazine of the State Bar of Texas, and is published monthly and is sent to all licensed Texas attorneys, as well as all paralegals that are members of the State Bar of Texas's Paralegal Division. That journal will have lots of ads of experts who advertise their services for attorneys. And of course, you can go to the internet and run searches and see if you can find any experts that might be viable candidates that way. Now, once you found someone that and contacted someone that you think might be a potentially good candidate, there are certain things you need to request from that expert so that you and your supervising attorney and client can evaluate whether or not this is someone you want to hire. First of all, you need the expert's resume. And in the expert world, they're usually not called resumes. They're called curriculum vitae, or CV for short. If you don't want to try to pronounce the Latin, just say CV. Attorneys and experts know what that means. It's simply their resume, laying out their educational credentials, their work experience, and their training, and their professional associations and licenses, and so forth. You're definitely going to want to see that. In addition, you're going to want to see a list of all publications the expert has authored in the last 10 years. You're also going to want to see a list of all lawsuits in which, in the last 4 years, he or she has testified as an expert, either at trial or by deposition. And you're also going to want to see the fee schedule. That is the charges that the expert will charge for the expert's services in serving as an expert. And this would include the cost to study the materials of the case, conduct any inspections as necessary, preparing a written report laying out the expert's mental impressions and opinions, and the charges for testifying in a deposition or at a trial or hearing. Usually the fee schedule is an hourly basis fee, and sometimes it is a graduated schedule where each one of these categories of activities may be at a different hourly rate, the highest usually being to testify in a deposition or at a trial. So you're going to want to know all of this. Now, you're also going to want to find out whether any court has ever disqualified this particular expert from ever testifying as an expert, either because he or she is unqualified or because he or she has used methodological approaches that have not been properly peer-reviewed, or maybe are just, according to the court, junk science. You definitely want to know that before you commit to hiring an expert. It's a good idea to conduct a civil and criminal background check on the expert, just in case there are any hidden landmines that might rear their heads, sorry to mix the metaphor, in the lawsuit, such as, has the expert ever been sued for malpractice or fraud? Is there any criminal background that could come back to haunt the expert in your case, or any other wrongdoing that might give your opponent impeachment ammunition? Also, make sure your potential expert has never testified in other cases to opinions that might contradict the opinions that he or she would give in your case. And you'll want to be sure that all the materials you obtain about this expert are sent not only to your supervising attorney for review, but also to the client. Now, in the process of evaluating the candidacy of an expert, it's a good idea to try to avoid hiring quote-unquote professional experts or hired guns. These are persons who frequently testify as experts. Some of them may make 100% of their living testifying for plaintiffs or defendants in lawsuits. And this will be especially something to avoid if the expert tends to always testify in favor of plaintiffs and your client's a plaintiff. Or conversely, if the expert always testifies in favors of defendants and if your client is a defendant. Because this will come out at trial, you can guarantee it, and a jury may perceive this person as being a mere hired gun hired gun who will simply give whatever opinion that this person is paid to give, and that will cause the person to lack credibility in front of the judge or jury. So you want to try to avoid the professional expert or hired gun expert. Now, when you have hired an expert, you need to remember that the opposing party, if it's a testifying expert, the opposing party will be entitled to obtain in discovery all the materials the testifying expert reviewed in forming his or her opinions to be given in the case. It is therefore very important you keep a careful record of all documents and other materials that your firm has provided to the expert for review. And it's a good recommendation to provide usually only copies of documents, because you want to safeguard the originals, and to Bates label all pages of every document that you give to the expert. Bates labeling is a mechanical way of sequentially page numbering every document in a set of documents. And you want to make sure that every page you have given the expert is page numbered sequentially from 1 to whatever it is, so that you will always, and to keep an index of what each page number is, so that there will never be any dispute about what the expert did or did not review to prepare for his or her expert testimony. Another thing to remember is that a testifying expert has to be unbiased and independent. If there's any ground to question that, the opposing attorney will catch it, either in deposition or other discovery, and that might subject the expert to impeachment at trial. That is, the expert's credibility may be attacked at trial. And so you need to be careful never to say, orally or in writing, anything to a testifying expert that could even remotely be interpreted as attempting to influence the expert's opinion, or attempting to bias or prejudice the expert in favor of or against a particular party in the case, or attempting to suggest to the expert what your client does or does not want the opinion ultimately to be. You want to make sure that you keep everything as completely bare bones as possible in terms of your communication with the expert. Some lawyers will not allow any oral communications with an expert. Others will only allow the attorney to do so. So the attorney can keep an extremely close control over what the expert is told to avoid any possible mishaps in this regard. So just keep this in mind. Now, under the federal rules, there is what's called the attorney-expert communication protection. That is, in federal courts, and it's different in Texas state courts, but in federal courts, communication between a party's attorney and that party's retained testifying expert are generally not discoverable by the opposing party. But there are exceptions to this protection, and they're so broad that you don't want to risk it. And the exceptions are if the communications relate to how the expert will be compensated for his or her work, they're going to be discoverable. If these communications identify facts or information that the attorney provided and that the expert considered in forming the expert's opinions to be expressed, they will be discoverable by the other party. And if the communications identify any assumptions provided by the attorney that the expert relied on in forming the opinions to be expressed, then those communications are discoverable. So again, these are big exceptions, and you don't want to take any risk that any communication could be even remotely construed as attempting to influence the experts or compromise the expert's independence in reaching his or her conclusions. Okay, so that brings us kind of full circle here on the factual side of the investigation. We've looked at the basic sources of probative facts. You have your own client, you have third-party witnesses, you have exhibits, and then you have potentially expert reviews. Well, and of course, remember, anything you can get from the opposing party was likely going to have to wait till formal discovery once the lawsuit is filed. Well, now you have all these facts. And remember, a cause of action consists of two components: facts plus an applicable legal theory that the facts support and thereby justify the client to sue. So now the step is, based on the facts that you have, you need to ascertain any legal theories that those facts might support and justify a suit on legal grounds. And so you may know this already. You may already know what the elements of negligence are, and you don't need to do any legal research. But if there's any question, or if you want to make sure you've covered all possible causes of action, you may need to do some legal research. Now remember that each legal theory that could form the basis of a cause of action will consist of a series of elements or specific facts that the plaintiff will have the burden to prove at trial to win. And how do you find these legal elements? Well, one easy way is to browse the pattern jury instructions, or as we call them in Texas, pattern jury charges. These are standard form jury questions or instructions that pertain to the most common causes of action, defenses, and remedies that are asserted in various types of cases. They are in turn based on the applicable primary law, such as statutes or case law in the particular jurisdiction. And so if you wanted to go, for example, to the Texas pattern jury charges to see what would a jury be asked in a fraud case to determine whether or not the defendant committed fraud. Well, that's a good way of ascertaining exactly what evidence your client would have to put on at trial to win a fraud case. And in Texas, the pattern jury charges are published by the State Bar of Texas. They're called the Texas Pattern Jury Charges, or PJC. They're several paperback volumes, and they're divided into basic practice categories like family law, negligence, business law, and so forth, malpractice, and so forth. And this is a good, easy way to find out exactly what the elements are, because you'll be looking at exactly what what standard the jury will be asked to apply in its finding of whether or not someone committed the tort or the breach of contract or the fraud or whatever the legal theory is. In the federal courts, these are called pattern jury instructions. And each intermediate circuit court of appeals has its own pattern and jury instructions for the most common federal causes of action. And so you would need to go to the circuit court of appeals that would have jurisdiction of appeals for cases in the states in which you expect your client's lawsuit to be filed. You can just go to the court's website and they'll have a link for them. And that'll be a good source if the cause of action arises under federal law. But if you don't have a pattern jury instruction or pattern jury charge that fits your situation, then you could just simply do the research in the primary sources of law themselves, such as the applicable statutes or case law. Now, I've already mentioned that some examples of legal theories are negligence, intentional infliction of mental distress, fraud, false imprisonment, breach of contract, violation of Title VII of the Civil Rights Act on the federal level. So there are lots of different legal theories out there. And again, remember that each legal theory will consist of multiple factual elements, all of which the plaintiff will have the burden to prove by a preponderance of evidence at trial. So here are the examples of the elements of a simple negligence case under Texas law. If your client has a cause of action for negligence, or in determining whether your client does, your research would reveal there are 4 basic elements your client would have the burden to prove. First of all, your client would have the burden to prove that the defendant owed your client a duty under the law to exercise reasonable care under the circumstances then existing. Secondly, your client would have to prove that the defendant breached or failed to comply with this duty by failing to exercise reasonable care. Third, your client would have to prove that this breach of duty was a proximate cause of the plaintiff's damages. That is, there was a causation nexus between the defendant's breach of duty and the harm that the plaintiff suffered. And then the final element is that the plaintiff actually had to have suffered harm, actual harm. Harm will not simply be presumed. So these are the four basic elements of a negligence case that a plaintiff has the burden to prove. Once you know a potential cause of action that may fit the facts, then it's to organize your facts in a way that helps you analyze how they relate to the cause of action. You'll want to create a litigation chart, also known as a categorization of evidence. And this is simply a chart that sets out those elements your client would have the burden to prove at trial, and for each of those elements, what evidence exists and how you would prove it. So the chart essentially would be divided into separate sections for each element of the legal theory the client must prove. For example, if it's for negligence, there would be 4 elements: duty, breach of duty, proximate cause, and damages. And then for each of these elements, you'd want separate boxes in the chart to describe the facts or evidence that you currently know of that either support or refute that element. So you need to include facts that are both favorable and unfavorable to your client. You don't just put what helps the client. The litigation chart is supposed to give you a starkly realistic picture of the status of the client's situation. And then you're going to want a separate box to describe the source of each of those facts, so you'll know where it came from. Did it come from the oral interview of a particular witness? Is this information that came from a document or a photograph? You'd want to indicate that. And then finally, you'll want a box for how to indicate how that particular fact could be introduced in evidence at trial in an admissible form. And normally this will involve naming a witness who could testify to the proper foundation, or who could testify orally to whatever the fact is based on personal knowledge. Also on your chart, you're going to want to note any gaps. If there are certain parts there where you have no evidence, or where you need additional facts that will have to be obtained in formal discovery in the lawsuit, make a note. This will help guide and be a blueprint for the formal discovery to be performed once the lawsuit is filed. So here's an example of what a litigation chart or categorization of evidence might look like. You can see here that in the left-hand column, we have the fixed elements of what your client would have the duty to prove: duty, breach, proximate cause, and damages. And then below damages, I've just listed some examples of specific elements of damages that a plaintiff can potentially recover for in a negligence case, if it's a personal injury or a case that maybe also involves property damage, like a car wreck case. And so next, in the column next to each of these elements, in the column labeled facts, you would simply describe whatever facts or evidence you have that relates to each one of those elements. And again, if it hurts the client or helps the client, doesn't matter. It needs to be noted. In the third column, for each of the facts, you need to identify the source of the facts, like the name of the witness or the document. And then in the final column, where it says trial witness, you need to name the witness who could be the sponsor of the evidence, such as the witness who could testify to it, the witness who could lay the foundation for it. Or if it's a self-authenticating public record, you could just indicate the title of the document to indicate that it's self-authenticating, and you don't need a witness to sponsor it. So, and you could add other elements of damages or delete them as appropriate for your client's own condition. So this is just an example of how a litigation chart might look for a simple negligence case in Texas law. Now, if you prepare your chart and it turns out you have at least some facts or evidence to support every element of your client's cause of action, then your client has what's called a prima facie case. Prima facie is simply Latin for at first sight, and that means a case in which at least some facts, that is proof or evidence, supports every element of the client's cause of action. That's a good thing, but remember that having a prima facie case does not necessarily guarantee the plaintiff will ultimately win at trial, because it's still possible the defendant may have contrary evidence, and once you get in front of a jury, the jury may find that the defendant's evidence is more credible than your client's evidence, and so your client still theoretically could lose the case, but having a prima facie case is very good because it helps you avoid filing any frivolous lawsuits, and it shows that at least you have some evidence to support these elements, and that your case is not completely um, unfounded. Now, one thing you're definitely going to have to check out is once you have a sense of the cause of action or causes of action that your client may have, you need to very carefully determine, is there any time limit that may be involved in filing the lawsuit? I'm calling these time barring issues. You need to know that a defendant will have an absolute defense to a particular cause of action if the plaintiff waited too late to file the lawsuit on that cause of action. Now, determining how late is too late will depend on the type of remedy the plaintiff is seeking in the case. If the plaintiff is seeking legal remedies, that is money damages, then you would need to go to the applicable statute of limitations to see how late would be too late. On the other hand, if the plaintiff is seeking equitable remedies, that is non-monetary relief, then you would need to apply the common law doctrine of laches to determine whether or not there may be an unreasonable delay, or could be, that might prejudice the defendant and be unfair under the specific facts or circumstances of the case. So you need to be very careful to, if you determine there is a deadline, say under the statute of limitations, that needs to be communicated to your attorney right away. It needs to be put on the calendar to make sure that if your attorney takes the case, that the statute of limitations is not missed and that the lawsuit is filed before the statute of limitations period has expired. It is a big source of malpractice for plaintiffs' law firms to when they should have known about a statute of limitations, or they did know about the statute of limitations, and they inadvertently didn't file suit in time. Now, let's talk about this, the first type of time barring issue, and that is the statute of limitations. Then we'll look at the doctrine of laches. But a statute of limitations is a statute enacted by a legislature, that is, it's not common law, that establishes a fixed maximum time period in which a plaintiff may file a suit seeking a legal remedy. And this time period will begin to be calculated on the day after the plaintiff's cause of action accrued, that is, arose. So again, the statute of limitations is a statute. It's not a common law judge-made doctrine. It is the work of the legislature in question, and it establishes a fixed maximum time period, normally in terms of a year or a certain number of years, such as 2 years, 3 years, 4 years, and so forth. And this is the period in which the plaintiff can file a suit seeking money damages. If the plaintiff waits after this period has expired, the plaintiff's claim is barred. The statute of limitations has said to have run or expired, and the plaintiff no longer can seek that remedy. The idea is that there has to be a point at which a potential defendant can be assured that the defendant won't be sued. For example, if you had gotten a car accident, let's say you accidentally rear-ended somebody and that person waited 20 years to sue you. Well, that's, the law and the theory underlying statute of limitations is that there's got to be a reasonable point beyond which you are no longer exposed to liability, even though the plaintiff might have had a valid cause of action back then. So this is an incentive to plaintiffs not to sleep on their rights, to file their lawsuits timely, and also to give potential defendants the assurance that they won't be subject to liability, way off in the future beyond what is reasonable. So the statute of limitations provides for a fixed deadline, and it usually is in the period of a certain number of years. And so if the plaintiff's cause of action accrues on, say, March 1st, then the very next day will be day one of that maximum time period, and it just goes forward. And as soon as that period has expired, if the plaintiff files suit afterward, the defendant has an absolute defense based on the statute of limitations. Now, how long the limitations period will depend on what legal theory is being asserted as the basis for recovering the money damages. So if it's a cause of action for money damages, that is legal remedies, arising under state law, then the state's statutes of limitation will govern that duration. So in Texas, if it's a common law cause of action, such as negligence, breach of contract, fraud, and that sort of thing, then the duration of the limitations period will be governed by Texas's general statute of limitations, which is Texas Civil Practice and Remedies Code, Chapter 16. This would include negligence, which is a 2-year statute of limitations, breach of contract, which is a 4-year statute of limitations, unless the contract provides for a different limitations period. But if it's a statutory cause of action in Texas, such as under the Texas Deceptive Trade Practices Act or under the Texas Insurance Code, then that particular statute will contain its own special statute of limitations that will provide the limitations period, such as the Texas Deceptive Trade Practices Act, which provides a statutory theory for suing a defendant who's lied about a product that the defendant sold to a consumer, will also contain its own provision that limits how long a plaintiff can wait to sue, and that would be 2 years. Now, on the other hand, if the cause of action for the legal remedy arises under federal law, such as Title VII of the Civil Rights Act or Federal Tort Claims Act, then the federal statute in question will have its own statute of limitations pertaining to suing under that particular federal law. So the statute of limitations will limit and provide a fixed time period for a plaintiff to sue seeking legal remedies, that is money. Well, what if the plaintiff instead wants to seek an equitable remedy, that is a non-monetary relief, like an injunction or a declaratory judgment or a decree of specific performance? Well, you don't look to statutes of limitations in that situation. Instead, any barring of the suit based on waiting too late to sue is governed by the common law doctrine of laches. Laches is an old word that means something like remissness, meaning remiss or not, or kind of sleeping on your rights and not filing suit in time. But it is a common law doctrine. Unlike statute of limitations, it's not something that the legislature enacted that bars a plaintiff suit seeking equitable relief when, under extraordinary circumstances in that particular case, granting the equitable relief would be extremely unfair to the defendant as a result of the plaintiff's delay. So Unlike a statute of limitations, the common law doctrine of laches does not impose an arbitrary fixed deadline for filing suit in terms of years. Rather, whatever delay was involved in filing suit will be evaluated by the court in light of all the facts and circumstances of that particular case. And the court will, the doctrine will bar the suit if, under those circumstances, it would be extremely unfair to the defendant to grant that equitable relief now because of the plaintiff's delay. So it's a much more case-specific, fact-specific inquiry. There's no such thing as an arbitrary time deadline like there is under a statute of limitations. Okay, here's a summary of the differences between a statute of limitations and the doctrine of laches. You'll be seeing this distinction throughout your paralegal courses again and again in the program. Let's start with the statute of limitations. The remedy that is affected by a statute of limitations is a legal remedy. The statute of limitations will govern claims by a plaintiff seeking legal remedies, that is, money damages. By contrast, the doctrine of laches will affect claims by plaintiffs who seek equitable relief, that is, relief other than money. Now, the source of this time barring issue for a statute of limitations is, of course, a statute. It is a provision enacted by a legislature, whether, say, the Texas legislature or the U.S. Congress. By contrast, the doctrine of laches is a common law doctrine. It's a judge-made doctrine that has evolved and been articulated in numerous court decisions. Now, what is the standard for deciding how late is too late for a plaintiff to receive the relief requested? Under a statute of limitations, it is a fixed time period specified by statute, such as 1 year after the cause of action accrued, or 2 years after the cause of action accrued. And the length of this period will vary depending on the specific legal theory under which the plaintiff is seeking these legal remedies. Now, by contrast, the doctrine of laches does not involve a fixed time period at all. Instead, the court will analyze all of the facts and circumstances of each specific case and would essentially ask, did the plaintiff's delay in filing suit cause or involve such a change of circumstances that it would now be extremely unfair and unjust to the defendant to grant the equitable relief? If so, then under the doctrine of laches, the plaintiff's claim for equitable relief will be barred. So again, no fixed time period under the doctrine of laches. It is essentially a doctrine of fairness. Finally, when does this period of limitation begin? Well, in a statute of limitations, whatever the period is, 1 year, 2 year, or 3 year, will begin to be calculated the day after the cause of action accrues. Normally, a cause of action accrues when the injury occurs. So if you are rear-ended on Central Expressway today, and that means you've been injured today, then this is day 0, and tomorrow will be day 1 to calculating the, say, 2-year period of limitations period to sue the defendant for negligence. Well, what about the doctrine of laches? Well, this question doesn't apply. Because remember, the statute of limitations, the doctrine of laches does not involve a fixed time period. So you can't say that the period began or didn't begin, because that's not the inquiry when a court is applying the doctrine of laches when the plaintiff is seeking equitable relief. Instead, it's based on all the circumstances of the case and whether or not the plaintiff's delay in filing suit would render this equitable relief grossly unfair to the defendant at this late date. And that is a case-by-case inquiry. And so when the period begins is simply not applicable in the doctrine of laches. So I hope this gives you a basic idea of the time barring issues, but it is incredibly important, especially with the statute of limitations, if you work for a plaintiff's firm, to make sure when does the statute of limitations expire or run, and make sure that deadline is carefully put on the firm's calendar every which way but loose, and that your attorney knows about it so that your firm does not inadvertently file suit too late. That is a big malpractice problem for plaintiffs' firms. So that brings us to a close on this lecture on investigation informally and fact gathering before suit is filed, and I thank you for listening.